Hello, everyone. Welcome. We're going to get started now. So first of all, I want to say hello and welcome to our first Human Rights in Practice event of the spring 2025 semester. We're so glad that you've all joined. This event is on prisoners' rights in the U.S. and abroad. As always, the Human Rights in Practice events are hosted by the Center for International and Comparative Law and the International Human Rights Clinic here at Duke Law School. I also want to acknowledge our co-sponsors today, of which there are several. Today's event is co-sponsored by the ACLU, the American Constitution Society, the Duke Decarceration Project, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Law Wrongful Convictions Clinic, the Duke Law Criminal Defense Clinic, the Human Rights Law Society, the Innocence Project, the International Law Society, and the National Lawyers Guild, which I think reflects how much interest there is in the student body and at Duke Law on these topics. We're joined today by three exceptional women. Two are online, behind us on the screen, one here in person, who work to protect persons in detention from mistreatment and violations of their rights. Each of them will speak a bit about their work to protect prisoners' rights, and then we'll turn to a Q&A with all of you here in the audience. Our first speaker today is our speaker who's here in person, Emily Wanger. Emily is a civil rights lawyer at Emery, Celli in New York City, and she's worked extensively on a variety of civil rights matters. Those include, for example, matters relating to the rights of persons in custody, in prisons and jails in the United States, the rights of people who've been discriminated against in housing and employment, and wrongful convictions. After Emily, we'll turn to one of our speakers online, Nyari Pariola. She's an advocacy specialist at the Center for the Study of Violence and Reconciliation in Johannesburg. It's a nonprofit organization focused on violence, reconciliation, and sustainable peace building. Nyari has worked within the South African and African regional systems on the prevention of torture and other forms of ill treatment, including in detention settings. She's also worked previously with UN Women, King's College London, and Lawyers for Human Rights. Finally, we'll then hear from Verity Coyle, also online. She's a senior advisor and campaigner at Amnesty International's International Secretariat in London. She's also a senior advisor at the Stimson Center's Conventional Defense Program. Her work covers various arms control issues, including helping lead advocacy for a new torture-free trade treaty to ban and regulate the trade of equipment that can be used to commit torture and other forms of ill treatment, including in detention settings. So, you're not here to listen to me. We're all very grateful to have these three incredible speakers with us today to share their expertise with us. So with that, I'll turn the floor over to Emily.
Thank you so much, Professor Rafferty. I want to thank Duke and the International Human Rights Clinic for inviting me to be here today. I feel so honored to have the chance to speak with all of you about the work that I do and to be here with these other two very distinguished panelists. So, as Professor Rafferty said, my work focuses on civil rights law, and a good portion of the work that I do involves representing incarcerated individuals and their families whose constitutional rights have been violated while they were in custody. So most of the rights at issue in the cases that I work on involving people in prison derive from the Eighth Amendment of the U.S. Constitution, which of course, as many of you probably know, involves prohibiting cruel and unusual punishment. So quite a few different rights kind of flow from that underneath the umbrella of the Eighth Amendment. So for example, there's the right to be free from excessive force and sexual abuse, the right to be free from assault from other incarcerated people while in custody, the right to humane living conditions, and the right to adequate medical care, including adequate mental health care, among others. So these are all rights that people in custody in prison in the United States have. The difficult part, of course, is enforcing those rights and especially vindicating them in federal court when the legal standards and procedures that are in place in the US are really stacked against them. So I'd like to speak a little bit about one case that I worked on a couple of years ago involving a young man who died in custody in state prison in Oklahoma, and then think a little bit about the ways that this case is an outlier and kind of how it sort of got around some of the obstacles that you would typically encounter when you're thinking about bringing a case on behalf of somebody in custody. So this case that I want to tell you about, like I said, I worked on it a couple of years ago. It involved a young man who had been sentenced to about a year in prison when he was 20 years old for a nonviolent property offense. And so he was serving his time in a state facility in Oklahoma. He had gotten through most of his sentence. He was a few months away from being released when he began to experience abdominal pain. He went to the medical clinic in the prison and saw a medical staff member explain what was going on. They basically said to him, "This is not a big deal. Take some Pepto-Bismol, go back to your cell. This should be better in a few days." Obviously, it didn't get any better. And over the next week to 2 weeks, his pain got worse. He started experiencing other classic symptoms of appendicitis. He went back to the medical clinic multiple times to seek more care. And each time he was told basically the same thing: this is not a big deal. He wasn't seen by a doctor. He did not receive a thorough physical abdominal examination. He was just given, medications akin to Pepto-Bismol, given ibuprofen, and told to go back to his cell. On the last day of his life, he went back to the medical clinic again, and the medical staff gave him an EKG. It was clear that his heart rate was extremely elevated, but they told him to wait for somebody else to come see him, and he couldn't wait. He was in too much pain, so he went back to his cell. The nurse actually went and saw him at his cell, but told him if he wasn't willing to walk back to the medical clinic, he couldn't be treated, and he couldn't walk because he was in too much pain. So he passed away in his cell a few hours later after the nurse left him there without giving him any treatment. So obviously, probably many of you know that appendicitis is just a very common, routine, treatable medical condition, and I have no doubt that if he had, been treated by the medical providers who he sought assistance from, this young man would not have died. And it's just a really, really horrible, tragic case. So my colleague and I represented this young man's parents in bringing a lawsuit against the medical staff who failed to provide him with care and the prison administrators who hired them. And after years of litigation, we settled the case for about $1 million, which is actually, I think, the largest known settlement resulting from a death in custody in the state of Oklahoma. Obviously, no amount of money can bring this young man back, but the settlement, of course, represented some small measure of justice for his grieving family, and hopefully will spur some reforms in Oklahoma because this settlement had to actually be approved by the Oklahoma legislature, so it wasn't sort of just a behind closed doors kind of thing. But to me, like I said earlier, the broader significance of this case isn't the fact that we were able to reach this settlement, but instead it's the fact that this outcome makes it an extreme outlier in cases that are brought by people in prison. This case was actually featured recently in a Business Insider series that surveyed cases brought by people in prison over the course of 5 years under the 8th Amendment, and actually found that only 1% of those cases resulted in the person in custody prevailing in court. So that's not settlements. Settlements is separate. I think the number of settlements was something like 14%, but actually winning in court, only 1%. And there are a variety of reasons why it's so hard for people who are in prison to win, to bring cases and win in court. And I want to just touch on a couple of them, time permitting. So the first reason that I want to talk about, which you may have heard of, is a piece of legislation passed in 1996 called the Prison Litigation Reform Act, the PLRA. The PLRA was designed to reduce the number of quote unquote frivolous cases brought by people in prison, but in reality and practice has made it so much harder for people who are incarcerated to file and win lawsuits, including meritorious lawsuits. So the PLRA limits incarcerated people's access to courts in many ways, including by requiring courts to dismiss cases for minor technical reasons before even reaching the merits if they're filed by people who are in prison. requiring incarcerated people to pay filing fees, even though people who are low-income people who file in federal court who are not in prison can have those filing fees waived. If you're in prison, you can't. And it also disincentivizes attorneys from taking these cases by capping the attorney's fees that you can win at the end of a lawsuit if the plaintiff prevails at a below market rate. So that's another thing that the Business Insider piece found, is that incarcerated people who were represented by lawyers were far more likely to win their cases than if they were proceeding on their own or pro se. And the PLRA makes that really difficult. Another obstacle to vindicating the rights of people in custody, which you may have heard of, is a legal doctrine called qualified immunity, which protects state and local officials from individual liability unless the official violated what's called a clearly established constitutional right. And this doctrine applies more broadly than just in cases brought by people in prison, but I'm just talking about it in that context. So qualified immunity, which you may have heard of again, means it's not enough for someone in prison to show that their rights were violated. They also have to show that another court found that substantially the same acts were constitutional before this happened. So in the case that I discussed earlier, the court found that the medical staff members were actually not entitled to qualified immunity, but in many other cases, this is a huge bar to vindicating the rights of people in prison, because if anything is different, if it's a different context, if there's some way to argue that this right, although you may have it, your right was violated, if it was not violated in the same way previously, then the official is entitled to qualified immunity and you can't get relief. And lastly, the last obstacle that I want to touch on very briefly is just the substantive doctrinal law that applies in these cases brought under the Eighth Amendment alleging denial of medical care. And that is called deliberate indifference. And it makes it really, really hard for plaintiffs to prevail, except in very extreme cases. So the term deliberate indifference basically means that the plaintiff has to prove that the bad actor, so the prison guard or the medical staff member, was both aware of and disregarded a serious risk of harm. So it's not enough to show that an objectively reasonable medical provider or prison guard would have been aware of a risk under the circumstances. You actually have to prove a mental state. You have to prove that the person subjectively realized that there was a serious risk of harm and didn't act on and didn't do anything to avoid that risk of harm. So in the case I talked about earlier, there was a lot of evidence that the medical staff knew that the young man was at a serious risk of harm, but in other cases, it can be really hard to prove, and this is oftentimes fatal to people vindicating their rights that have been violated in prison. So despite these obstacles, I feel like this has been a little bit of a walk through all of the reasons why it's hard to do this kind of work. But despite this, I feel really honored to get to do this work. And civil rights lawsuits, I believe, are a really critical tool to protect the rights of people who are incarcerated by holding bad actors accountable and pushing governments and government agencies to make changes. And obviously, my work focuses on the litigation section of this, but this kind of change would not be possible without efforts of people to make change through legislation and through social movements, and it all sort of needs to be done hand in hand in order to really protect the rights of people who are incarcerated in the U.S. But that's just a little snapshot of the kind of work that I do and the kind of considerations that we think about when bringing cases on behalf of people in prison.
Thanks so much, Emily. I know that was a heavy topic, right? So rather than turning to questions from Emily now, we're now going to turn to Nyari Pariola, who's joining us online, who will talk about her work in the African regional context. So Nyari, I'll turn the floor to you now.
Thank you so much, Mrs. Jillian. Good morning, everyone. I think it's morning for most of you. It's evening for me, and I think afternoon for Verity. Thank you so much for having me here. When I was thinking about what's the best use I can make of the 10 minutes I was given, I thought it would perhaps be, especially in light that I'm bringing a regional perspective, I thought, that it might be useful perhaps to just give you really a broad overview of the regional policy framework, of how this issue plays out in some of the national contexts, and also just give you a brief insight into some of the case law that has really unpacked what this means. So really, we're going to do a marathon here of the African regional context. I hope that the Madam Chair will give me maybe an extra 2 minutes. Having said that, so yeah, so as she said, my name is Nyari, and I'm an advocacy specialist at CSPR. I also, in my capacity as that, I coordinate a continental network of service providers that work with victims of torture, victims and survivors of torture on the continent. And really, mainly, we lobby the regional mechanisms in terms of the rights of the survivors of torture, particularly around reparations. Some of our key highlights in terms of achievements that we've had so far is we've managed to successfully lobby for the adoption of the resolution on rehabilitation of torture victims in Africa, and also for the Commission to adopt a general comment on redress of torture victims. Yeah, so I just thought I'll share that to start off with. But now to actually get into the marathon of the regional context, what you find is okay. So this is also how I'm doing it, right? I'm looking. I thought let me look at maybe how can I say the general situation of human rights of prisoners in Africa generally first, and then I'm going to then really come down and do a slight deep dive, if you like, into torture prevention itself and just the issues of torture on the continent. So what you recognize is that although Africa is home to at least 52 countries of profound diversity, there are several common themes that emerge when we look at the issue of prisoners' rights. It's clear from that African prisons face a host of challenges, including deficits of good governance, funding, and other resources. And many African prisons are in a deficient condition, and their practices are at odds with human rights standards. However, it is also clear that several governments and organizations on the continent have committed themselves to improving the lot of Africa's incarcerated by promoting prisoners' rights. And as a result, what you'll find is that actually Africa is now home to several innovative instruments and institutions that are aimed at protecting the rights of those behind bars. I thought I would maybe just start with some stats in terms of just how African countries relate to the international legal framework or system. And you'll find that 52 of the 54 African member states have ratified the UN Convention Against Torture. 21 African countries, which is actually a considerable number, have ratified the OPCAT, the optional protocol that speaks to the establishment of national preventative mechanisms. And also, in terms of the Universal Declaration of Human Rights, there's universal ratification, although 13 African countries still retain the death penalty. The African Commission on Human and People's Rights is the one that really, at the regional level, plays the most significant role in terms of improving prison conditions through their oversight of the African Charter on Human and People's Rights, which was adopted in 1986. And through the Commission's mandate through from the Charter, they do this through investigations and adjudications of rights violations. They also investigate African prison conditions. They establish working groups, and one of the most important things that they did in 1995, the Commission adopted the Resolution on Prisons in Africa, which essentially extended the rights and protections that are set forth in the African Charter to prisoners and detainees, as they had not previously been included. An additional instrument that the Commission has adopted is the Robben Island Guidelines, which were adopted in 2002. And these encourage African states to adopt minimum international standards on prison conditions and give detailed instructions on how to achieve them. So they're a really useful instrument that we have. They make specific recommendations, including physical conditions of prisons, the use of alternative sentencing to mitigate overcrowding, judicial independence, increasing awareness and training of staff, and separation of vulnerable groups such as women and children. You also have the Robben Island Guidelines, also then created the Commission for the Prevention of Torture in Africa, which is really the premier body that of the African Commission that is that oversees the issue of torture on the continent in actual fact. And since its establishment, it's been the focal point. And their principal mandate really is to actually raise awareness about the Robben Island Guidelines in member states, and to encourage and foster greater compliance of African states with their obligations under Article 5 of the Charter, which of course includes adoption of relevant legislation. Yeah. Another way that the African Commission also, oversees this issue is through the Office of their Special Rapporteur on Prisons and Conditions of Detention in Africa. And the main mandate of the Special Rapporteur is to inspect and report on prison conditions, and also to communicate with African governments regarding the state of their penal systems. He also entertains individual complaints about prison conditions and reports to the Commission on his findings on a yearly basis. He also is supposed to, he or she actually is also supposed to propose solutions to challenges facing African prisons, and to train law enforcement personnel, police, prison guards, administrators, and lawyers in actual fact on improving prison conditions. Now, in terms of progress, now I'm going to just really quickly look at the progress that has been made on the continent in this regard, with regards to prisoners' rights in general. Since the 90s, especially at the turn of the century, the situation has dramatically changed and improved, in actual fact, for prisoners in Africa. In most countries, constitutions with detailed provisions of fundamental rights and freedoms for all people, including prison inmates, were enacted. And in addition, you're finding actually that, especially from since the turn of the century, that most governments have on their own volition also established other mechanisms to monitor and investigate and report on conditions of prisons in general and the treatment of inmates in particular. And different African Union states have also passed legislation which makes specific provisions regarding the rights of inmates, and also that specific anti-torture legislation. I'll now outline some of the different mechanisms that have been put in place in recognition and protection of prisoners' rights in some of the African countries. What emerges from both the legal instruments and court decisions is that the way and this is a big takeaway I hope you can take away, is that the way in which prison authorities and staff handle inmates under their care has come under strict scrutiny in recognition of inmates' rights on the African continent. What this means, of course, in practical terms, is that prison officers not only have to be increasingly aware of and sensitive to prisoners' rights, they also have to change their working practices to conform with these important individual rights and freedoms that are being recognized and pronounced upon across the continent. With regards to constitutional provisions, you found many countries, Zimbabwe, South Africa, Namibia, really almost, I think, 3/4 of the African countries now have constitutions that, anyway, with the advent of democratization on the continent, that contain basic fundamental rights and as of individuals. As part of the provisions protecting individual rights, for example, constitutions of Namibia and Mozambique outlawed the use of death penalty as a form of punishment. And the lawmakers in these countries took the bold step and were courageous enough to join few other progressive countries in the world to abolish capital punishment by making express provisions in the constitution, instead of leaving that to be decided by superior courts. Also, in addition to constitutional provisions, like I said earlier, some governments have gone further to establish human rights watchdog institutions. So in South Africa, for example, Chapter 9 of the Constitution establishes what are known as state institutions supporting constitutional democracy. The institution here that's relevant to our purposes is the Human Rights Commission, which has just recently actually been designated as the sole NPM. Prior, since 2017 or 2019, it was a combination of what can I say, offices that formed the NPM. But now Parliament has just said that the Human Rights Commission on its own is now the national preventative mechanism. Tanzania, on the other hand, was the first country to establish the Permanent Commission of Inquiry in 1967 that also looked into these issues, and their Commission of Human Rights. Ghana has a Commission of Human Rights. Uganda, on its part, has the Office of the Inspector of Government as well as a Human Rights Commission. Several countries in the region have also established ombudsmen, is what we call them, that have mandates to investigate rather human rights abuses and report annually to Parliament. You found that in Namibia, for example, that allowed, complaints from prisoners without any censorship, that most of the complaints that the ombudsman reported to parliament were actually from prisoners. And then in terms of legislation, some countries in the region have amended, repealed their legislation and made it now to be in line with the constitution as well. Now I'm just going to quickly turn to case law, where as you all know, courts are usually referred to as the custodians of justice. This is also true in regard to the role that they play in protection of inmates' rights in particular. Um, so if I thought it would be very useful for us to look at some of the case law, and the following examples are from the South African context. Um, prison, yeah. So in the case of S versus Makwanyani, the Constitutional Court decided abolished the death penalty in South Africa. Our constitutional negotiators were unable to do what Mozambique and Namibia had done. This was a unanimous decision. Also, the Constitutional Court, when they were faced with another question regarding the rights of inmates in terms of whether corporal punishment by organs of states was constitutional or not, they also took a unanimous decision saying that it was not. And in Namibia, for example, when inmates challenged the constitutionality of the use of leg irons, for example, the Supreme Court of Namibia had no hesitation in declaring the practice an invasion into individual dignity, and consequently unconstitutional. They were also willing to order compensation for the inmates. And in the one case, the applicant actually got 15,000 Namibian dollars as general damages for pain and suffering and the impairment of their dignity. Now, literally, I'm in my last 3 minutes, I think. I'm going to do the quick deep dive into the torture, more specific though, to torture prevention. So what you find is that many countries have constitutional provisions that criminalize torture. Some states also have specific anti-torture legislation and national human rights institutions. In Kenya, they have the Prevention of Torture Act, which criminalizes torture, and they also have a National Police Service Act, which includes provisions against police brutality. However, enforcement remains weak. A case example from Kenya, Mape versus Attorney General. In this case, the Kenyan High Court awarded damages to a torture victim who had been unlawfully detained and abused by the police. The ruling reinforced the judiciary's role in holding state actors accountable. In South Africa, as I said, we have our NTM now, and I just wanted to share a case example of State versus Adonis, where a South African police officer was convicted for using excessive force during an arrest, marking a rare case where torture-related abuse actually led to criminal prosecution. In Nigeria, although there's human rights-based prison reforms, there's even an Anti-Torture Act of 2017 which explicitly criminalizes torture. However, what you find there is that torture by security forces, particularly in counterterrorism operations, remains prevalent. Think Boko Haram, insurgency. Also, another case example would be the SARS abuses and End SARS movement, where protesters exposed the systemic torture by this special anti-robbery squad. And in response, the Nigerian government actually disbanded SARS, though accountability for past abuses remains limited. In Uganda, yeah, I'm almost finished. I promise I've got 3 more slides. In Uganda, they have an Anti-Torture Act 2012, which is a landmark law that criminalizes torture. The Human Rights Commission also actively monitors detention centers, but reports of torture persist. The case example from Uganda is the Nalufenya Detention Center case. This was a notorious detention facility that was closed following allegations of severe torture and extrajudicial killings, demonstrating the impact of legal advocacy. So what are the challenges to torture prevention, particularly around detention settings, weak enforcement and impunity of legal frameworks and impunity? Despite strong laws, impunity remains a major obstacle. Overcrowding, poor detention conditions. Many African prisons operate at over 200%, leading to inhumane conditions. For example, Chikurubi Maximum Prison in Zimbabwe. Inmates there suffer from malnutrition and lack of medical care. Makala prison in DRC, there's severe overcrowding conditions leading to death in custody. You also have low prosecution rates for future cases, limited independence of some of the oversight bodies, fear of retaliation discourages detainees from reporting abuse, and some states have not ratified OPCAT. So, of course, this limits external oversight and also weak enforcement of recommendations that are made by the Human Rights Commission, and of course, police interference in judicial and oversight mechanisms. Uh, uh, yeah. And then I just thought to finish with recommendation, to that more African states need to ratify and fully implement OPCAT. We need to establish independent oversight with investigative powers, reduce pretrial detention to ease prison congestion, train law enforcement on ethical interrogation and human rights, enhance access to legal aid for detainees, and promote collaboration between government, civil society, and international bodies. Thank you.
Thank you so much for that, Nyari. That was an incredibly rich contribution, which with so much to share that I think probably a lot of data that too many people in this room aren't familiar with yet. So thank you so much for sharing that. Verity, I'll pass the floor to you now, and then we'll head to Q&A after that.
Thank you, Professor Rafferty, and thank you, my fellow panellists. It's so lovely to be in this space with you, and thanks to all the students and faculty that are here. I'd like to start with some framing. I'm going to talk about torture in US prisons and then how we at Amnesty and our partners see a potential torture-free trade treaty as contributing to the reduction of torture in the US and abroad. It is horrific to note that in the last 5 years, Amnesty International has uncovered evidence of torture and other cruel, inhuman and degrading treatment or punishment in at least 94 countries in all regions of the world. When a person is tortured, their dignity and integrity are cast aside. They become mere tools for achieving whatever purpose their abusers seek. Torture is the total denial of a person's human rights. Far from being a medieval practice eradicated in modern times, torture continues to thrive the world over, mostly in places where people are deprived of their liberty. People in detention are especially vulnerable to torture and other ill treatment, given their deprivation of liberty and subjugation to state power and control. In some maximum security, isolation or segregation facilities across the USA, many thousands of inmates are held in solitary confinement in small cells for 22 to 24 hours a day. Many have little access to natural light or out-of-cell recreation time, which amounts to cruel, inhuman or degrading treatment. Some prison officials are torturers. They may torture prisoners to punish them, to make them give information about other prisoners, or to frighten them to obey the rules. In 1995, the chain gang, a powerful reminder of past abuses, was used for the first time in more than 30 years. However, shackling prisoners has been a continuing feature of the US penal system. Prisoners are routinely shackled when being transported, whether or not they pose any risk. Pregnant women being taken to hospital are commonly shackled. Some authorities shackle pregnant women at their wrists, ankles, and waists, despite the increased dangers that they may fall and suffer serious injury. A wide range of technologies designed to control and incapacitate inmates has been developed in recent years, resulting in practices which are cruel, degrading, and sometimes life-threatening. Michael Valente died in March 1997 in Utah State Prison after being shackled in a restraint chair for 16 hours. A hole had been cut into the seat to allow him to defecate and urinate. Although no longer employed in that prison, restraint chairs are widely used across facilities throughout the USA. In some jails, they are used to deliberately inflict cruel punishments. Other methods of restraint, such as chemical sprays and electric shock devices, are frequently applied, despite the fact that some are inherently unsafe and invite abuse. Electroshock stun belts, for example, are increasingly being used. At the press of a button, a powerful electric current passes through the wearer, causing severe pain and instant incapacitation. Much of the equipment mentioned just now is on the list of equipment, about 20 items, that we would like to see prohibited through a torture-free trade treaty. And the push for a torture-free trade treaty reflects the understanding through proposed prohibitions and controls that more should be done to prevent law enforcement equipment being used to inflict torture or ill treatment in both custodial and extracustodial settings. Despite the categorical prohibition of torture and other cruel, inhuman or degrading treatment or punishment under international law, and I've been having a back and forth with Jillian about this, so if you'd like my written comments on this, please do get them from her. There is an absence of international standards which have prevented the emergence of a comprehensive and coherent global response. In May 2022, at the request of the UN General Assembly, a group of governmental experts set up by the UN Secretary General released a report A/76/850, seeking to address this gap. The group recommended the establishment of common international standards and put forward the option of a treaty, a legally binding instrument to achieve this goal. We believe this treaty should have two central aims. First, to prohibit the production of and trade in equipment used in law enforcement that has no practical use other than for the purpose of torture and other ill treatment. The type of equipment I mentioned at the top of this talk that is used daily in US prisons. And second, to establish effective human rights safeguards to control the trade in law enforcement equipment that has a legitimate function but can be used to commit torture and other ill treatment, and to stop businesses profiting from acts of torture and other ill treatment and prevent states that supply this equipment from contributing to those abuses. NGOs, human rights activists and journalists have pieced together aspects of the trade through open source investigations of equipment filmed or photographed at protest sites and documented in places of detention. Equipment sales have tended to follow historical colonial ties. For example, French equipment is widely found in Francophone Africa and Lebanon, as well as regional influence, hence the predominance of manufactured or licensed equipment from Brazil, Spain, and the USA across Latin America, or Chinese equipment in Africa. Under international human rights law, states are required to take measures to give effect to their obligations. We have this distinction that's emerged between the two types of equipment, inherently abusive and other law enforcement equipment. There are many examples of what this equipment is, and I urge you to read the Special Rapporteur's torture report that goes into this in detail. She's outlined two annexes of where she sees the prohibited goods and the controlled goods demarcation lying. You could argue that the obligation to prohibit and prevent torture means that states should be taking action in this area, but there's no international body or mechanism that is saying this is required yet. So a torture-free trade treaty would fill a gap in the existing legal architecture. It would fit alongside existing obligations without creating duplication or confusion, and it would help advance the evolution of understandings of torture and ill treatment as human rights violations that law enforcement officials inflict in a variety of different custodial and extracustodial settings, and that equipment is often used in these violations. What these prohibitions and controls on law enforcement equipment through a torture-free trade treaty would mean practically is that they would help take the inherently abusive equipment out of circulation and limit risks that other law enforcement equipment could be used for torture and other ill treatment. Thanks, Jillian. I'll stop there.
Thanks so much, Verity. That's so helpful in the international law framing and to discuss the work that you guys are doing toward the torture-free trade treaty. So I want to open it up for the Q&A now. rather than Phil, while I have plenty of questions I would love to ask our wonderful speakers, I'll open up to the students first in case there's anybody who's really itching to ask a few questions.
Thank you all so much. I was wondering if you think that some of the persistence of these practices has to do with a lack of consensus around why we incarcerate people to begin with. I don't know if there's more of an international consensus about that than there is in the US, but it seems like there's a lot of debate here about the purpose of prisons. So I'm wondering if some of the cruel tactics and equipment that you've described stems from that lack of agreement about why we're doing this in the first place.
Sure, and I'll just repeat the gist of the question to make sure the folks online could hear. Excellent question. The student asked if the speakers think that the reasons there's that this treatment persists has to do with maybe disagreements or controversy around why we incarcerate people to begin with, what the purpose of incarceration is, and if that encourages, those disagreements may encourage or permit ill treatment, and if there's maybe a difference between that, if there's consensus on that front at the international level as opposed to nationally. So I don't know if either of the speakers online want to chime in on the international side and welcome on the domestic side. You want to go ahead?
Sure. So I think it's certainly possible that that's one of the reasons why conditions are so terrible in many U.S. prisons, and I think that there's also the fact that prisons are mostly run. I mean, there's obviously the Federal Bureau of Prisons, but that's really only a very small percent of people who are incarcerated in the U.S. are incarcerated in federal prison. Vast majority of people are incarcerated in state facilities, and so it's very much like a state-by-state policy setting situation. And of course, the Constitution provides a background of like what's supposed to be a backstop of, you cannot go beyond certain levels and setting certain standards that must be met. But I think that there's certainly an aspect of in the U.S. there being a history of unclear objective, whether it's punishment, whether it's rehabilitation, whether it's something else. And then I think there's also in the U.S. this sort of feeling that, in my opinion at least, the way that a lot of legal doctrines in constitutional law involving the rights of people in prison have evolved in the U.S. Has to do with giving prison staff a lot of leeway in terms of how to maintain order, how to ensure that there's safety supposedly in prisons. And so I think that a lot of courts, a lot of the doctrines that have arisen have kind of given, in my opinion at least, have sort of abdicated responsibility a little bit to the people who are running the prisons to determine what is quote unquote necessary in order to maintain order in prisons. And that leads to just very permissive standards. You have to, like I said, was talking about earlier, you have to meet like such a high bar in order to show that somebody's rights have been violated in prison. And I'm not sure, I feel like I maybe strayed a little bit from your question, but I think that there's, I definitely think that you're getting at something when you talk about sort of uncertainty as to why we incarcerate people in the U.S.
Just before I take another question, I want to call on Nyari as well. I know your hand is raised, so I assume you want to chime in. I think in particular on that distinction Emily was making just now, you talked about the role of courts, especially in protecting prisoners' rights. And so Emily just talked about how courts in the U.S. have a very deferential sort of attitude toward those who run prisons. I wonder if you could chime in from the sort of regional perspective in Africa on that same question.
Thank you. That's actually the very point I wanted to know.
Perfect.
But before I get to the case law, I just wanted to also just say, one of the writers on this issue actually speaks about the historical context to prisons in Africa and makes the case that before colonialism as such, that African countries didn't actually have prisons, at least in the format that it presents now in modern times. That prisons came with colonialism, and at that time they were really mainly used for political, to incarcerate political opposition, to ensure that, whatever sort of rebellions were happening, that they took all those so-called troublemakers and put them there. I mean, think a modern example, of course, think Robben Island, just in how it was used to incarcerate political prisoners. So, and the argument that they were making is that, what has happened in post-colonial Africa is that we have sort of kept that colonial model of our prisons that, if once you get to prison, you actually, because of whatever you've done, and so, okay, for instance, thinking of just normal criminal, if you like, who's committed a crime as we understand it, that, because of whatever crime you've committed, you don't actually deserve any rights. Once you get into prison, that's it. That's where you belong, and you should have no rights because of what you've done to society. But also across African countries, what you find is incarceration is also linked to politics, right? Where you find that, for example, let's say in Chad, some of the main perpetrators of torture belong to the same ethnic group as the president's ethnic group. So now you realize that there's also, a whole lot of politics that comes in with regards to why people are in prison, or even, elections and torture have very close relationship in Africa, where you'll find that, most people during election time, there'll be so much torture so there's this sort of understanding that you are political infidel or whatever, so you deserve sort of this treatment and you have no rights. And what kind of recourse are you going to get? There won't be any kind of recourse. But now, coming to the case law, it actually had to be a pronouncement that courts had to make, as democratization happened, and particularly as we got our constitutionalism really took off on the continent and legislation started being put in place that sought to give effect to the constitutional provision, that courts also, for the longest time, really had a hands-off approach in Africa. They used to defer very much to prison officials, but you then had very key case law where the judiciary made a very clear pronouncement that, in actual fact, a prisoner doesn't lose their right just because they've gone to prison. They still have their fundamental rights, and those ought to be protected, you know. And you're finding now that courts are more and more engaged in actually fighting for the rights of prisoners. I'll give you, to end off, an interesting case example from South Africa, where these inmates, so HIV is another big medical issue. Speaking of medical issues in detention settings, HIV is a big issue and a problem for us. And these inmates brought a case asking that the courts that they get access to treatment for HIV, but they wanted really specialized treatment. And what the prison officials were arguing was that no, even in terms of the constitution itself, they're only allowed access to the same treatment as a person would get in a regional hospital, a public service hospital, right? But in this case, the court actually then held that no, they could have access to the specialized treatment that an outside person wouldn't get. Because why? He says because the conditions in prison make them more vulnerable would escalate the disease or whatever more. So because of that, they can get the specialized treatment. And the funny thing is, there wasn't that much pushback. Like even people that sort of spoke about this decision, they actually sort of applauded him for his bravery in making this kind of judgment. So it's like really was swung all the way to the other side, at least in some African countries. Thank you.
Thank you, Nyari, and those are really excellent examples. Other questions from the audience? Alice?
Yes, thank you so much for your presentation. Going off of what you said about, state prisons and each having their policies, but also extending that to the world, do you see, or are there studies that show why some states or some countries have worse, they treat their prisoners worse than others? What cultural bias or context underlies that situation? And a second thing is there a country that has a better system that we can start looking at to evolve from that and achieve a systemic solution for prisons?
I think there was another question. I may take both at once to make sure we have time to get to both. You had a question, right?
Mine is actually somewhat similar, but regarding capital punishment and whether, because it seems the United States is behind, and the other places have declared that capital punishment will be used, and there's been some callback in the U.S. very recently. So I wanted to know how, if there are the cultural underpinnings towards the reflection on that status of capital punishment, and where it seems to be moving globally for states who might have been more neutral on it, or might have been very progressive on it, and those who might have been more conservative on it, how that might be moving from state to state in light of more recent changes.
Sure. So, and then we'll take one more, and then I'll say all three for the folks online. Go ahead, Bettina.
So my question is on excessive solitary confinement, and I always wondered why this has not yet been declared as unconstitutional, just because there are a very wide range of examples where we see the psychological impact that solitary confinement has on prisoners. So I'm just wondering why, because we have examples of what it does to people, it has still not been declared as unconstitutional. And my other question is, when you spoke about the deliberate risk of harm, I don't really understand why that threshold for prisoners is so much higher than if we would be in an out of prison situation. Because when we say that just because you're in prison, you're not a second-class citizen, why are the institutional frameworks then so different?
Okay, great questions. So I'm going to summarize them for the folks online, and I try to draw a few together to make it easier to lump all the answers in before we run out of time. So the first question had to do with why the trends on how prisoners are treated are worse in some places than others, and if there are good models. Are there best practices or good models in certain countries? Are there countries that are getting this more right than others as far as respect for prisoners' rights and protection from mistreatment go? The second question sort of said, okay, let's talk about that with capital punishment. It's maybe not going so well here in the US, or we're behind maybe global trends. Where are the global trends going on that? And then there was, again, a similar question about solitary confinement, but more specifically in the US context, why isn't it unconstitutional? And likewise, why are folks that harm prisoners held to a different standard than folks that harm people outside of prison? So I would say most of these sort of fall in the maybe there's some bad examples and good examples. Why are the bad things happening, right? Basically. What cultural factors or social factors or policy factors make these examples of bad treatment happen, whether it's in a general sense or around capital punishment or solitary confinement. And then separately, the US, that last question is very US specific. So I think we could chime in from anybody online as well. Maybe Verity, do you have thoughts on good versus bad models for this, and who is the good example, and how do we think about emulating that elsewhere?
On some of them, Jillian, I have to kind of disclaimer that this isn't me pulling Amnesty research. It's talking about things within the organisation and UN system that I've seen. I'll start with the death penalty, actually, globally. We are seeing improvement in the number of states who are either abolitionist in practice, if not in law. And we are seeing states move to abolish the death penalty completely from their books. We have a small group of states who are seeing any attack on their right to carry out the death penalty as an attack on sovereignty. And this political argument goes much broader than just the use of the death penalty. And we're seeing that play out across all of the UN discussions at the moment. So Singapore would be the most visible opponent to any attack on the sovereign right to commit capital punishment. But there's a group of friendly states within the UN that run the moratorium resolution every year, and they are continuing to see good progress on support for that resolution. And then domestically in different countries, governments and parliaments taking the action necessary to end their use of capital punishment. On the good versus bad in terms of how prisoners are treated globally, my personal opinion is that this swings in alignment with political will from who is the government of the time and how do they view prisoners, which kind of relates to your question about is a consensus around how prisoners are treated. I volunteer in Holloway Prison one of the maximum security men's prisons in the UK once a month. I go into the drug and alcohol wing, and I work with the men in there as a former addict myself. And many of them are back as multiple offenders because they relapse, because they are not able to access support and care that they need to tackle their addiction. And yet when I work with them, when they're in the middle of a 3, 6, 12-month stint sober and clean, they have deep remorse and don't want to be criminals and don't want to be offending. So I think there's a kind of what do we do with prisoners after prison question, as well as how we treat them at the point of arrest and detention. And on excessive solitary confinement, Greenland has just been taken to task and changed its laws, but it had massive uses of solitary confinement up until recently, and it was the torture and other ill treatment argument that eventually allowed us to change that there. Thanks, Jillian.
Yeah, of course. Thanks so much, Verity. That's so helpful. Emily, maybe now I'll turn to you on the solitary confinement and the deliberate harm question.
Yeah, absolutely. So on solitary confinement, I think there have certainly been efforts to get solitary confinement declared to be cruel and unusual punishment in courts, and courts just haven't found that that's the case. And I personally haven't litigated any of those cases, so I'm not sure I really can speak to what are the reasons that courts have given for finding that solitary confinement is not doesn't fall within the Eighth Amendment prohibition on cruel and unusual punishment, but there have been, I know, significant efforts to legislate and ban solitary confinement or significantly limit solitary confinement. So from my perspective, it does seem like movement in that space is going to come through legislative fixes and not so much through litigation. I think New York had recently passed a law that cuts back the amount of time that people can be left in solitary confinement, and there are other states that have done similar things. And the other question was about deliberate indifference. So I would say, and I'm not a historical scholar of sort of how this doctrine has developed, but my sort of conjecture is I think it may go back to what I was talking about a little bit earlier in terms of the kind of leeway that courts have given to prison staff and administrators as to how to basically, create order and security and safety in prisons. And I think, in my opinion, courts have sort of given too much leeway and sort of have taken the stance that prison officials and prison guards need to be able to make like snap decisions. They need to be able to take action without fear of getting sued later in order to maintain order in prisons, when in reality, more oversight, I think, would actually be the thing that would allow for better order and more security in prisons, as opposed to giving guards sort of like unchecked power. But I think that that's kind of where that concept comes from, of saying like, no, it isn't just would an objective person have known that there was a serious risk of harm here, but actually did this particular person in this instance realize what they were doing, which again, it makes change really difficult and remedies really difficult to get in court, but I think that that's where it comes from.
So we are out of time. I want to give the folks online, if anybody has a last, I think Nyari, maybe you wanted to chime in one last time before we close.
Yes, please. I just wanted to contribute to the solitary confinement issue, and just give an example of best case scenario, perhaps, or best practice, if you like, outside, of course, of a total ban, which is the direction I think we should all be going in. But in South Africa, for example, the legislation really puts some critical safeguards in place around solitary confinement. I'll just read some of the conditions under which the use of it is very strictly controlled. If you're going to use solitary confinement, for example, you have to refer to the office of the inspecting judge, and he has to first give the authorization. The prisoner must receive the same diet as usual. He's entitled to an hour of exercise per day. Cannot be held in solitary confinement for longer than 30 days. Must be visited at least 4 hours by a correctional official. Must also be assessed at least once a day by a nurse, medical officer, or psychologist. and solitary confinement, for example, must be discontinued if, in the view of a nurse or medical profession, it poses a threat to mental or physical health of the prisoner. So I just thought to share that I think we are slowly, hopefully, moving towards a total ban by putting in place some critical safeguards regarding that. Thanks.
Thank you for that, Nyari. So we are out of time. I know folks have class to get to, so normally I would give you all a chance to say a last word, but I want to let people get to class. I will take the privilege to say the last word, which is that while this is a very bleak topic, I hope that what you've heard from our speakers today inspires some positive outlook about the work that's being done to protect the rights of prisoners and fully realize those rights, because it does make me feel that way. Thanks all for coming, everybody. Thank you again to Verity, Nyari, and Emily for your excellent contributions. Thank you guys online.